Good evening. It is my pleasure to welcome you all to this very special session of the Iowa Supreme Court. My name is Diane Crookham Johnson. I'm a member of the Mahaska County Bar Association and the Mahaska County Magistrate Judge. I would like to thank the Iowa Supreme Court Justices and their team for bringing their work to Mahaska County tonight. What an opportunity we have to see our judicial branch at work in person. Later tonight, after the court adjourns, everyone is invited to attend a public reception in the lobby. The justices will be at this reception, eager to visit with you. Please feel free to strike up a conversation with any of them. You do need to know, however, that judicial ethics prohibit the justices from speaking about pending cases, so they cannot discuss the case you will hear tonight. They can speak in general terms about court procedures, the role of courts, and any other topics you want to ask them about. Before I explain the work and role of the Supreme Court and the process we are about to observe, I want to thank, on behalf of the court, some of the people who have helped with the arrangements for this event. Thanks to Oskaloosa High School Principal Jeff Kirby, George Daly Auditorium folks, Randy Wright, Andy McGuire, Allison McGuire, Erica Smith and their team for preparing this wonderful auditorium for tonight's event. And thanks to Lynette Lindgren, Mahaska County Bar Association President, and the entire bar for hosting. Additionally, the court thanks the Mahaska County Sheriff's Office and the Oskaloosa Police Department for providing security. Now I will discuss briefly how the Supreme Court works and the process we are about to observe. Many of you have probably seen a trial, either in real life or portrayed in a movie or a TV show. Some trials are in front of a judge and some trials are in front of a jury. Maybe some of you have served as jurors. If so, I offer you our thanks for your service. So what happens after a trial ends? When a party is unhappy with the result at trial, the party may appeal the case to a higher court, called an appellate court. An appeal is a higher court's review of a lower court decision or judgment to assure that substantial justice has been rendered. The right of appeal is a fundamental element of procedural fairness as generally understood in this country. The appeal process is very different from a trial. In trial court, one judge presides over the case and makes decisions based on the evidence presented at the trial. In an appellate court, a group of judges are collectively responsible for making a decision. Why do appellate courts have group decisions? The basic concept of an appeal is that questions about legal procedure are decided by a group of judges rather than merely substituting the opinion of one appellate judge for that of one trial court judge. Tonight you will see an oral argument. Oral argument is an opportunity for the lawyers to emphasize certain legal principles of their case, not new evidence for a case, and for the Supreme Court to ask the lawyers questions about the case to help clarify the parties' legal arguments. Don't be surprised if the justices interrupt the lawyer's argument to ask questions. Time is limited, and the justices may want to focus the argument on particular issues in the case. You can find more information on the Iowa Supreme Court, the appeals process, and a summary of tonight's case in the program that you picked up at the door. Before the court begins, I want to mention some rules of decorum of conduct during our oral argument. During the proceeding, please be quiet and respectful of others. Please turn off or silence all electronic devices, including cell phones. If you must leave the auditorium, please do so quietly. If you really have fun tonight, you can drive to Des Moines anytime and watch more of these oral arguments. We thank you tonight. Please enjoy this unique opportunity with the Iowa Supreme Court, and please join us for conversation afterwards. Thank you.
All right. of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. Thank you for joining us. This is an oral argument that if it were not taking place in Oskaloosa, it would be taking place in the Judicial Building in Des Moines. Thank you very much for coming to see how this goes. We will now begin oral arguments in the case of State versus Khalen Williams. As the appellant, Ms. Wilson, you may begin.
May it please the court. My name is Teresa Wilson and I represent the defendant, Khalen Williams. Mr. Williams was a passenger in a Lyft vehicle that was stopped for a valid traffic infraction. An officer who responded to the scene recognized him from an earlier eluding incident and issued him an exit order. In 1990, this court held that when an officer conducts a traffic stop on a vehicle, the officer cannot issue an exit order to a passenger without reasonable and articulable suspicion that the passenger was either engaged in criminal activity or was armed and dangerous. 7 years later, the U.S. Supreme Court in Maryland v. Wilson held that no such individualized suspicion was required for an exit order of a passenger. There are two questions for this court tonight. First, does the Iowa Constitution still require Terry suspicion for the exit order of a passenger? Second, was there a valid basis for finding a valid Terry reasonable suspicion for the exit order as to this defendant?
And let's deal with that second question first. Didn't the officer know a number of things? First, that the individual in the back seat had been involved in an eluding incident, and did he also not have a weapons violation?
The officer at the time, Officer Poltan, did know about the eluding incident from 14 months before, where the defendant was the driver of the vehicle that failed to stop. There was a quick chase. The defendant was armed. There is no allegation he threatened the officer or pointed the firearm at the officer.
But there was a firearm involved in the prior incident, was there not?
Yes.
All right, so why isn't that enough for a Terry type stop? When the officer knew that the person in the back seat, A, had run before, and B, had carried a weapon. From that can we infer that he's not carrying a weapon of some kind, which might be a danger to the officer?
No, Your Honor. First, the incident was 14 months prior. My question is, when is the scarlet letter removed? Secondly, in that particular incident, it was the defendant's own conduct that resulted in the officer being involved. In this case, it wasn't the defendant's conduct. He was simply a backseat passenger in a Lyft vehicle. Third, the second eluding incident that the officer was aware of, there is absolutely no allegation of a firearm in that incident. We know very little about it. So really, what Officer Poltan was going off of, according to his report, was his instincts that the defendant was armed. The defendant,
I want to ask a question. Justice Apple referred to a couple things, the eluding and the weapons violation. But that isn't the point where the Terry Pat occurred. Wasn't there more activity by the defendant at that time, such as back and forth questioning and some concern by the officer that went beyond those two things?
well, there's what Officer Poltan testified to, and then there's what the other available evidence corroborates. And there's a contradiction between his testimony and the video and his own report. So Officer Poltan testifies that he
went up to Mr. Williams, recognized him from the eluding incident, and immediately started asking him about that incident, that he then asked the defendant if he were armed. And at that point, the defendant broke eye contact, his demeanor changed. And then Officer Holtan asked him to exit the vehicle. And then there was also some arguing about that he was just a passenger. And Holtan also pointed out that, well, he had his hands up and away from himself, as if to show he possibly could be armed. Well, if you look at the video, the defendant has a very calm demeanor. And nowhere on that video does Officer Holtan ask him about a firearm. He asks about the eluding, then he asks directly about leaving the vehicle.
Did he justify what he did ask if that's during that 1 minute?
That is very convenient, but if you look at his suppression testimony, his testimony was clear. It was, we talked about eluding, I asked him about the firearm, I asked him to exit in that order.
I want to talk about that word convenient. Based on my understanding of the record, when an officer either puts his wig wags on or turns on his sirens or whatever, automatically the camera will kick on and it goes back 1 minute in video but not audio.
Yes.
For an officer who's by foot just sitting next to the car, standing next to the car, he has to manually turn it on, correct?
Yes.
Isn't that perhaps interesting that he turned it on at a certain moment? Help me understand. I'm wondering, did he turn it on because all of a sudden you started sensing something?
He may have turned it on because he knew who the defendant was, and his instincts told him he was armed. But the problem is, even if we believe that maybe this occurred in that first 60 seconds of audio, which seems uncorroborated because the timeline Officer Holtan gives in his testimony is eluding, asking, and then exit order. His own report contradicts his testimony. His report, he acknowledges, I put in what I believe to be relevant. The report does not mention asking the defendant about a firearm. It mentions talking about the eluding incident and then immediately asking the defendant to exit, which is what we see on the video. And even in his own suppression testimony, at the very beginning, Officer Holtan testifies that I asked about the eluding incident, and because I felt he was armed, I asked him to exit. No mention of a question about a firearm. That comes later.
But that eluding incident included a firearm, right?
Nobody disputes that.
So the officer's talking about the eluding incident, and the defendant knows what it is he's talking about. Both of the players know that there's a gun involved. Can't it be implied that they both, each one knew in that situation there was a gun? The word may not have needed to be uttered.
They may all have known that there was a gun in the eluding incident, but not in this incident. And we're not judging this incident by what transpired 14 months before. There needs to be some reasonable and articulable suspicion at the time of this stop that warrants having the defendant exit the vehicle.
Reasonable suspicion of what?
I'm sorry, can you repeat that? It's a bit muffled.
You said that at the time of the exit order, there has to be reasonable suspicion. And my question is, reasonable suspicion of what?
Reasonable suspicion that either the defendant is engaged in criminal activity or that he is armed and dangerous.
So, if he was armed, is that enough?
Under Terry, no, because it isn't just that a person was armed.
Can't you infer that someone who's carrying weapons is dangerous?
Lots of people carry weapons legally. They are all dangerous. Now, and the estimate in the brief that I found is going to be 1 in 14 million Americans legally carry firearms, and most do not cause any issue. The issue here is that we have an officer who issued an exit order based on his instinct that somebody was armed without any further movement. The defendant was cooperative. He was answering questions. And many of the things that the defendant was doing were innocent reactions, reasonable reactions to being essentially targeted by this officer. His hands are up to show he's not a threat, and yet the officer interprets that as he must be armed because his hands are up. He's talking about being just a passenger, but yet he was just a passenger. He was not culpable for the reasons for the stop, and yet he's being targeted by the officer. And
so what is the basis for deviating from federal law on the Iowa question? I think you would agree under federal law, the exit order was permissible.
absolutely, and that's what the district court found. So the Court of Appeals held that the defense didn't argue for deviation from federal precedent. In fact, the defense did. The defense argued for the Terry standard. And the only way you get there, because of the clear Fourth Amendment law, is through the Iowa Constitution. In this case, this court, when it had the opportunity to do so prior to Wilson, held that there is a distinction between drivers and passengers. That case is State v. Becker, and granted it was a Fourth Amendment case, but it was pre-Wilson. So Becker looked at both the driver and the passenger in that case, and they said minutes controls for the passenger, or for the driver, but also that because the driver, due to his conduct, would have been subject to full custodial arrest, any lesser intrusion was acceptable. But they couldn't say the same thing for the passenger because the passenger wasn't responsible for the
And
stop.
subsequent to that decision, the U.S. Supreme Court disagreed. So I guess what do you find deficient in Maryland versus Wilson that would justify a deviation from
The core, at least what it should be, of the Fourth Amendment, and what we've said under Article in Section 8 of the Iowa Constitution, is balancing. Balancing the interests of the officer and law enforcement versus the interests of the individual defendant. And Mims and Wilson provide absolutely no balancing. It is a blanket rule. There's no individualized suspicion required. And I think it's important to look at this case in the context of what exactly is being challenged. It's not the search of the vehicle. It's the additional intrusion or seizure of the person following the stop.
I want to ask a question about that procedure, and then you can get down to what you're saying, but are you asking for us to differentiate between passengers and a ride share, like your client was in a Lyft, or are you asking us to issue a rule that applies to all passengers in general?
Based upon the precedent of this court, all passengers. They didn't make a distinction between ride shares. And quite frankly, Justice Stevens' dissent in Wilson recognized that Wilson was going to apply to passenger buses, to taxis, to private cars. But this court, when it had the opportunity, pre-Wilson said, we don't recognize that. We recognize the distinction between drivers and passengers.
Well, Ms. Wilson, you just said yourself that what you don't like about Maryland versus Wilson is that it sets up a blanket rule and you'd rather have an approach that's more weighing or balancing. But doesn't your description of that approach raise some problems because you're arguing now that the officer Holden's testimony is incredible, shouldn't be believed, and if there's a blanket rule, we don't need to get into those issues. We just follow what Maryland versus Wilson said and come to the conclusion that based on it being a minimal intrusion, there's a blanket rule in order passengers out of the vehicle, just like the driver. Why not avoid all those arguments about whether the officer is credible or not?
It would certainly be easier for this court and district courts to decide because you just rubber stamp whatever the officer says. And there's no protection then for the individual person in the vehicle. Terry addressed this exact same situation. Everybody's concerned about officer safety. It's a legitimate concern. Maybe overweight based on new statistics on traffic stops, but it is a legitimate concern. But Terry told us how to address it because Terry addressed, the right that is sacred and most carefully guarded by the common law is the right to the possession and control of one's own person. And we balance those interests, the right of the person, by using this reasonable suspicion standard that allows swift action predicated on on-the-spot observations
But
and
think
officers.
back to the original Terry case. That doesn't involve a vehicle, doesn't involve a situation where the driver of the vehicle was violated the law, it was just a person walking down the street. In that case, the Terry standard makes sense. But once you add all the complications of a vehicle and you have and what's already admitted violation that the driver can be stopped for, what's the problem with Maryland versus Wilson?
Mr. Williams was already validly seized due to the stop. We don't dispute that. But passengers have an additional expectation of privacy because the basis for that stop is based on conduct that did not involve the passenger. And it doesn't take much. Officers know Terry. They know how to apply it.
Shouldn't we draw a line in this case saying that if you're a rider in a lift, a rider on a bus, or a rider in a taxi, that's different? In other words, separate this case from Wilson, saying that if it's a ride share, that there's a different rule.
You can certainly do that. That was the specific argument made below. I obviously brought in the argument to encompass the precedent from this court on passengers generally, but certainly you can do that.
You may summarize.
Keith, can I ask one question?
Absolutely.
Would we be the first court to do that if we made a distinction between lift riders and other passengers?
There is, to the best of my knowledge, no authority on that, and the attorneys below didn't find it. There's a long review comment and a Texas Criminal Court of Appeals case involving taxis, but those really talk about the right of the rideshare hire to control the vehicle, and not so much the person. Because we're talking about the person here being intruded upon, not just the vehicle. Thank you.
Thank you. State.
May it please the court. I'd like to first turn to the question of whether error was preserved on an Iowa Constitution claim concerning passenger exit orders. The Court of Appeals correctly pointed out that the defense did not ask for a departure from Maryland versus Wilson, and more importantly, the district court did not rule on such a claim, and no motion to amend or enlarge was filed.
But they did ask for departure because they didn't want a bright line rule. They made that very plain. And that is a departure from Wilson, does it not? I mean, they didn't cite the case, they didn't say, I want a departure. But the principle of the argument was right out of Justice Kennedy's dissent in Wilson, which is namely the distinguishing feature of our criminal justice system is its insistence on principles of accountable decision in individual cases. They're trying to urge the court to do the individual analysis. So surely, it was apparent that they wanted to depart from Wilson, but it's not.
I still disagree and argue that as a matter, in the Court of Appeals explain that in their opinion. As a matter of fairness, the defendant should be required to argue for a new constitutional rule or standard in the district court that would then give the state the opportunity to build a complete record and provide evidence and argument on that. By waiting until appeal, that deprives the state of such an opportunity to correct the record. Further, in the defendant's initial appellate brief, Williams did not reassert his claim that Maryland versus Wilson should not apply to paying passengers.
Well, that's true. That is true, but they certainly argued the broader principle that was articulated by this court unanimously in Becker in 1990, and it's been picked up by Massachusetts and Vermont and Washington and a number of state courts, namely the passenger is subject to different treatment than the driver of a vehicle in a traffic stop. Right?
Correct. This court did decide that in Becker.
Well, yeah, and And a host of other states under the state constitution have adopted the larger approach that she was resisting today. That I tried to tell them, and all that's true, right?
I'm sorry, I can't understand you that well.
I'm sorry, I think I'll try to make it clear. Is it clear? I think maybe it is. They did argue that in their appellate briefs that Becker distinguished between passengers and drivers, and that's correct. And also other cases in other Supreme Courts have adopted a different view than Wilson. And so isn't the macro issue of whether we inquire into the factual nature of the case, isn't that squarely before the court?
In some sense, yes.
I mean, I agree they didn't mention the lift distinction, and the cases out there haven't yet grabbed hold of it. That's a smaller distinction than they've argued. I agree with that. But anyway, why argue the policy? I read the quote from Justice Kennedy that says we need individualized accountability, and a Terry-type stop, a stop based on reasonable suspicion that someone is armed and dangerous, requires a particularized showing. Why should we require a particularized showing in this case, where the passenger is involved, not the driver, just like Becker suggested?
I think we need to separate out the law that pertains to passenger exit orders versus Terry pat-down, because they're two different concepts. If you look at Pennsylvania versus Mims and Maryland versus Wilson, the Supreme Court's focus was on balancing liberty, personal liberty interests of either the driver or the passenger with legitimate officer safety concerns. In Wilson, the court upheld the passenger exit order, pointing to facts that the passenger was sweaty, extremely nervous, and ducking down, raising officer safety concerns and warranting a minimal intrusion of asking him to step out of the car.
But you don't want us to make that. You're asking us not to get into the facts. You just say there should be a blanket rule that you can ask passengers to get out of the car, just like the Supreme Court has said the driver can be asked to exit. In all cases, no examination in any case. What you just read requires a particular action.
We don't think that Wilson stands for a per se rule that any and all passengers may be asked to exit the vehicle following any routine traffic stop. It is reasonable, as they did, to give the officer discretion to evaluate the circumstances as they encounter them, and determine how best to control the scene and ensure everyone's safety.
In the absence of the officer being familiar with this defendant or prior encounter, would there be sufficient facts to support reasonable suspicion?
Probably not. Those facts make all the difference.
Is the prior history sufficient in and of itself?
The state believes it is.
Do you read Maryland versus Wilson as requiring reasonable suspicion to order a passenger out of the vehicle, or do you read it as upholding the principle that the passengers can be ordered out just like the driver can be ordered out?
We don't think it stands for a per se rule that you can ask a passenger to step out for no reason at all. Many courts have considered whether or not, depending on how many people are in the car, what's going on with the driver, what other suspicions may be involved, what is the best way to control the scene and keep everybody safe, whether to keep people in, keep people out.
Could you address the issue whether we should treat Lyft drivers and rideshare for hire differently? Because you can assume that the passenger and driver are strangers. Does that make a difference? Should it?
I don't think there should be a distinction. Rideshare drivers drive their own personal cars, and they're not working all the time. Now, it was clear in this case that he was a Lyft passenger. People in private cars do not always have any nexus or relationship to their other passengers. They maybe just pick them up, give them a ride.
Ms. Hall, let me follow up one more time on this Maryland versus Wilson. I'm going to quote from the majority opinion that says, We therefore hold that an officer making a traffic stop may order passengers to get out of the car
Pending completion of the stop. The state's position is, what they really mean is sometimes an officer may do a traffic stop in order to passenger stop. Is that the state's position?
That's not the position that this court has applied over the years, with one exception of Becker.
I'm asking for the state position in this case.
The state's position is Wilson should stand and it's unnecessary to create a new rule under the Iowa Constitution. But appellate courts in Iowa have given officers the discretion, as the court did in Wilson. In State v. Riley, this court focused on a passenger's furtive movements in upholding the exit order and pat down, knowing that officers need not be absolutely certain that a person is armed in order to justify a search.
Well, don't you have to show dangerousness? And let me give you a hypothetical. Supposing a citizen is in the back seat and is visibly armed. Based on viewing the gun, can the officer require the person to exit and nothing more? My hypothetical, but you can see the gun right there.
I think it depends on all the circumstances. As in this case, when this officer had the personal knowledge and relationship with this defendant.
So the gun wouldn't have been enough.
Again, as the defense argues, with all the new changing laws on gun possession and open carry, etc.
The point is you need to have a specific showing of dangerousness. If he's waving the gun around.
Correct.
Okay. But so what is the showing of dangerousness in this case?
The officer relied on his personal experience and that he immediately recognized Williams from an incident 14 months earlier when he had chased him first in a vehicle at high speed and then on foot while the defendant was carrying a loaded weapon which he discarded at the end. Thus, this officer knew that he was then convicted of felony eluding and carrying weapons.
Is that a reason why we wouldn't maybe the defense's argument in the brief was lots of people can carry, lots of people do carry, things have changed. But in this case,
we don't think it's relevant.
Okay, I want to ask a question. Do you think an officer is in more danger or less danger if there's a passenger in the back car with a gun in his jacket, just like he did in this case, and then the officer says, get out of the car?
Again, it just depends on the circumstances.
Well, I just want to the argument is safety, the officer, but has the officer just made it perhaps less safe by ordering him out of the car?
Maybe, maybe not. It's dark, it's wintertime, the defendant's wearing a coat, and he also has the knowledge that another officer had arrested him for eluding in a vehicle he was driving and then fleeing on foot into an apartment building, and that was just 3 months earlier.
Is any of that even necessary to find here? Doesn't MIM state specifically that once the officer concludes somebody is armed, they are therefore dangerous for the purposes of Fourth Amendment? I mean, I think they're pretty clear about that in the opinion, aren't they?
That's what this officer testified that he believed, and he also based it on...
But as a legal matter, I mean, there's dangerousness in a factual sense, but armed and dangerous within the meaning of our Fourth Amendment jurisprudence, being armed is per se dangerous under MIMS. Isn't that right?
Correct, and then we also have the fact that he's a convicted felon and cannot legally possess.
So anyone who is visibly armed is subject to a Terry type search. Because he'd be armed and dangerous. Anybody who displays a firearm, permanent, not permanent, whatever, anyone who has a firearm visibly displayed is subject to pat-down Terry type search.
Not necessarily, again, it would depend on all the circumstances involved.
Is anyone who's a convicted felon subject to a Terry pat-down?
Maybe, maybe not. I think it depends on, the criminal history of this note, how long ago was it, is it stale?
So
what's he doing, just walking down the street on the sidewalk?
In the video in this case, Mr. Williams is compliant, cooperative, seems peaceful. What was it here that was that more beyond the criminal history that the officer had?
The officer testified that he first asked him about the prior incidents, and the defendant said he was on probation for eluding. And he had asked him if he was in possession of a weapon, which he did not answer. Instead, he deflected, which the officer called over-explaining, saying, "I'm just a passenger, I saw the driver was speeding," and he told the officer where he was going and held out his cell phone if he wanted to examine it. So it's at the 1 minute 34-second mark that the officer asked Williams to step out, and that's when he observed that he broke eye contact with him and appeared to freeze as if he was trying to decide whether to fight or take flight.
Well, so if you're a passenger in a Lyft car and the driver gets pulled over and then the police come to your window and start asking you questions, isn't it reasonable that you might freeze and think that there's something odd about that? I mean, is that a strange reaction by Mr. Williams?
It's hard to say exactly what he thought.
Here's what troubles me. I mean, I think if you apply Maryland versus Wilson, you end up where the district court ended up in this case. But what troubles me here is, it seems Maryland versus Wilson is predicated on an assumption that the driver's being asked out of the car, and so the rationale is if you can ask the driver to step out of the car, you can ask the passengers to. It's kind of maybe an unsafe situation to have the driver out, the passengers in, you're trying to watch two different situations at once. But in this case, the police were not really interested in the driver, they were just interested in the passenger. Doesn't that distinguish it from kind of the scenario conceived of Maryland versus Wilson?
Well, the officer that made the traffic stop, Officer Buck, was back in his squad car, still checking on warrants and IDs.
Both the driver and the passenger, but nobody asked the driver to step out of the car, they were just leaving him alone. Nobody engaged the driver in the conversation.
I'm not sure if the driver stepped out or not. I don't recall the video that well. I've seen my time is up. For all the reasons previously stated, the state would respectfully ask the court to affirm the district court's denial of the defendant's motion to suppress. Thank you.
Thank you, Ms. Hall. Ms. Wilson, when you're ready.
To answer your question, Justice Mansfield, the driver was eventually asked to exit his vehicle, but much after the defendant had already been placed into custody. He was not asked to exit.
That's my recollection too.
Yes. I want to go back to the question about the relevance of the prior history with the defendant being armed, and is that standing alone sufficient to warrant this reasonable suspicion that he is armed? And it kind of dovetails with the state's arguments in its brief that the state has actually conceded that in most cases, the courts have considered the fact that other factors were present for the movements in Riley, for example. In Bergman, you had a defendant who was in a drug area talking to a known drug dealer, having had a prior firearm incident with the officer at issue. And then both that person and the dealer disperse as soon as they see the officer, and then Bergman lies about where he had just been. So you have those factors in those cases. And in the Mendez case out of Washington State, that case also listed various factors that can be included in the analysis, and it includes the prior history with the defendant. But that case also questions whether that one factor can be it. And in this case, that one factor is really all Officer Holtan had. Officer Holtan came to the defendant because he recognized the defendant, and he essentially wanted to investigate the defendant.
Is 14 months too distant in the past? That seems fairly recent to me. Especially when it involves a weapon and running away.
I think it depends on the context, and that is why we need to use a multi-factor approach in these sorts of cases. And there's simply nothing other than this prior history that indicated the defendant was armed.
Was the officer allowed to question, just have a conversation with him?
Yes, I don't dispute that.
And so when he had that conversation and the officer observed what he thought was nervousness and over-explanation, should we stand in the officer's shoes and determine that, or should we give some credence to the officer who has that experience questioning people of what he would consider further movements or nervousness?
I think you look at the record, and the record shows that didn't happen until after Officer Holton issued the exit order.
Well, I've seen the video a few times, and I do get, I could be wrong, correct me if I'm wrong, but it seems to me that there's that one gap minute where the sound's not on, which means the officer at some point, and he didn't turn it on walking up to the car and would have seen it and heard it. So obviously, it's reasonable to assume he turned the switch after he was there and started having a conversation. Flips the switch, we see video, and then we start hearing too. It was before he ordered him out, correct me if I'm wrong, he said something about his phone and don't, put your hands out or whatever. And he said something like, don't put your hands in your pocket. And didn't he, by his own words, the defendant say, oh, I was just reaching in my pocket, which isn't it reasonable to assume that's a furtive movement. The officer may not have called it that, but he told him, don't do that. And by his own words, the defendant acknowledged, yeah, I just did something.
And that also happened after the exit order. So essentially what happens is the defendant seated in the back seat with his phone, texting, it appears. The officer has his flashlight, so he can see it. At some point, just prior to the exit order, the defendant puts his phone in his lap. And then the exit order comes.
And wait a minute, you forgot something else. Does the flashlight stop out there too? All of a sudden, we use flashlight.
Right.
Why would we lose the focus of the flashlight at that point? What should we assume from that?
I don't know that you're assuming anything from that.
I think the officer testified that that's about when we started fiddling around with getting ready to get thoughts done.
If I were the officer, I would think I would shine the flashlight even more on what he's doing with his hands, not less. I could be mistaken. But if it's about officer safety, that would be the first thing I would do.
Earlier you mentioned balancing and then common law rights. In some of our recent decisions, we've talked about looking at history and historical analogs to judge search and seizure issues. So what is the historical analog for not allowing an officer to conduct an investigation prior to the time of arrest? What common law right is being violated?
I'm not sure I have a good answer for that. It's simply that at common law, we do try to balance the privacy interests of the individual with the needs of law enforcement.
What case is that?
And unfortunately, they're more recent cases, but Khalen and Pals, Klein, probably.
What would be the tort that this defendant would have against the officer in common law?
That's beyond me, because I'm not a civil defendant. We would ask that this court reverse the ruling on the motion to suppress and reverse the conviction. Thank you.
Thank you. Case of State v. Wilson is hereby submitted. Technically, at this point, we would say court is adjourned, we would stand up and we would be dismissed. But I want to take a few minutes. I know there's people out there. You can see us a lot better than we can see you. But I would like to take this moment, first of all, to thank you for inviting us to your community, to invite you to a reception afterwards. I believe it's up out in that hallway, a beautiful hallway with all of the interesting things to look at. I don't know what it is, but typically it seems like a piece of punch. I'm just guessing. Please join us for that. We'll be out there. We're all from different parts of the state. We all have different backgrounds. We're more than happy to answer some of your questions. But also at this juncture, if there's anything you'd like to say about what we just did. We cannot talk about this case in particular. This is a real case that's being submitted. But just in general, if anybody is brave enough to ask a question, and I'll see if one of my colleagues wants to jump in and answer. Yes, I see you, somebody raising their hand.
Is this the normal amount of time that each attorney would have to express their appeal?
I'm going to just open it up for anybody to answer that question. I don't think we have a mic.
Our standard time is 15 minutes, 15 for the other side, and then 5, and the side that gets the extra 5 lost on the level below.
Any other questions? Yes.
So kind of going back off of that question, does it ever change, does the time ever change because of the case? Like, will the time change because of the case?
Okay, does the time ever change because of the case? Somebody want to take that? Justice McDermott?
Yes, it does. So there have been cases with lots of issues or more parties where we've had more time. So party might have 20 minutes, 30 minutes, it just can vary based upon how many issues the case has. Typically, it's 15, 5, unless there's something else going on.
You can't see it, but we have our own little baby traffic light up here. It's on top of that podium. Red light, green light, yellow light. I'll let you guys figure out what they mean. But green light means go. Go, and the lawyers are very, very familiar with that. Yellow light means just like a driving pod. Get ready to put your brakes on. And then red light means stop. And I think it was either Ms. Wilson or Ms. Hall, I can't remember which one, said that I know sometimes up. And so they're done. Or sometimes they might say, can I finish my thought? Or sometimes judges like Justice Fox at the end, towards the defendant's first argument, said, may I ask another question? And that was beyond the red light. That's why she said that. She'll pay that. But anyway, so, and then just to let you know, those lights are very common for all appellate courts, whether it's that system or whatever. That's a way of keeping trains on time. Another reason we might go over in time is sometimes it's what we call a hot bench, and lots of questions from the bench, and maybe we really didn't give the lawyers much opportunity to talk about what they kind of thought they wanted to talk about. So sometimes we're a little bit more generous with letting them go beyond the red light. Anyone else? Yes, sir, white shirt.
So it sounds like you all had a chance to review the evidence and the video. How much of that is given to you ahead of time, or is it submitted by the plaintiff or the defendant?
We get that right away when a case is, we decide to keep the case or take the case from the Court of Appeals. There's already a record that's been filed with our clerk of court, so we'll have access to the entire court file from the district court, plus the parties' briefing and any appendix they might prepare.
And follow up on that, some of our cases are actually submitted without oral argument, and so the parties' briefs, the written briefs, summarizing the arguments are really kind of the bread and butter of their arguments.
Yes, ma'am.
Apologies if I'm wrong, but it seemed like the appellate court denied to bring it to you guys. Did you guys summon the case, or how did it get to you guys?
How did this case get to us, Justice Apple?
Well, in the district court below, there was a motion to suppress the evidence. The motion to suppress was denied, so the evidence came in and the defendant was convicted. And then once he's convicted of crime, he has an opportunity to file an appeal. And he did file an appeal in this case. And then you have to, in your brief, outline the issues, the reasons why you think the district court got it wrong. You heard some discussion, questions based on the briefs. All appeals go to the Supreme Court, this group in the first instance. Some we keep based on a review of the briefs right from the get-go. Probably about 50 out of maybe 1,900 people. The rest of them are intermediate court, the Court of Appeals decides. They sit in panels of 3. Once they make their decision, the losing party has an opportunity to knock on our door again, called petition for further review, and we'll take 40 of those or 50 for kind of a grand total of about 100 cases a year. And the bulk of cases are handled by our intermediate court of appeals.
Yes, in front row.
There was a lot of reference to like the case of Maryland. What dictates deviation from common law in cases like this?
This one is getting, this one is maybe getting a little close to the specifics of this case. But in general, there is the Fourth Amendment that prohibits unreasonable searches and seizures. That is a prohibition in the United States Constitution. There is a parallel provision in the Iowa Constitution that prohibits unreasonable searches and seizures. We have the final interpretation under the Iowa Constitution, and we are not compelled to follow the federal interpretation as outlined by the U.S. Supreme Court. And in the past, on occasion, we have deviated from the federal interpretation when we think it's incorrect. So.
That's a general one. We don't want to get too much into that. I mean, those two ladies over there made their pitch for the question you asked. Anyone else? Yes, ma'am.
Will you make a decision on this case before you hear another case, or do you have several going at the same time?
Justice Fox, do you want to take that one?
We have several going at the same time. We heard arguments in Des Moines last week. We had about 16 cases submitted, and then each one of us is assigned to write a different case, and so we'll conference this case and kind of discuss afterwards what each of us thinks, whether or not we would affirm or reverse. The justice who is assigned to write the case will then draft an opinion and circulate it to the rest of the court, and then we'll either sign on to that opinion, or maybe if we disagree, we'll write what's called a dissent. We might agree with the outcome, but maybe not quite the reasoning, so we might want to write something in what's called a concurrence. And so then we'll issue a written opinion, and that can be anywhere from 2 months to 6 or 8 months from now. So this case will not be decided, will not be publicly decided and finalized for a few months, but we'll continue our other cases, and then next month we'll get another batch of 16 to 20 cases.
These are great questions. Anybody else? Yes, Deborah?
How do you decide which justice will write the opinion?
I'll answer that one randomly. And we're fair. We try to be fair as far as number of cases per month. We don't want to give Justice Apple 6 cases and Justice Waterman has none for the month. We try to be fair, and also maybe sometimes you can tell by looking at the case. Sometimes the record can be several thousand pages, just a transcript, and then the appendix could be a couple thousand pages. And we read every word. And so that justice in particular might need a little bit more time for that case. So maybe that justice that month will take one heavy case, and maybe someone else will pick up the load somewhere else. And also if we have a conflict, we know a conflict. I have family members that are lawyers, for example. Of course, when I have nothing to do with that case. If this case involved one of my family members, I wouldn't be sitting out here tonight. When the case is conference, I wouldn't be in the conference room. When they're sharing the opinion amongst themselves, I wouldn't see the opinion. I would read it when it comes up, and everybody else gets to read it too. So sometimes we cannot sit on a case, but typically we randomly assign them. I used to be a trial judge, and I like in the Appellate Court, I have a video or a picture. As a trial judge, I felt like I was on a horse like a cowboy. There's a bunch of cattle around me, 50 cattle, and I'm just trying to get them all lined up, and I'm herding cats, and that's my job, all these different cases. When I became an appellate judge, there's 7 people, and we're all looking at one cow. And we're all cowboys looking at one cow. But I feel more like a lawyer now than I did before, because if I'm assigning an opinion, and if I say I want to do X, and we go around the table and they all say, I'm doing why, pretty soon I'm outnumbered. I either be persuaded by them or I'm writing something called a dissent. So we have a lot of negotiating, persuading, cajoling, and educating with each other every day on this case. Anyone else before we go up to the reception area? By the way, I want to thank all the people who helped make this happen. It's not just us 7 sitting up here. There's people behind here that are affiliated with the judicial branch that helped make this happen. Law clerks are helping with bailing. We had lots of moving parts to make this happen. And I appreciate counsel agreeing to have a not so normal oral argument. They both are veterans. It was an easy thing for them to do, but it's much appreciated by the court. Any other questions before we officially adjourn? Oh, yes, I've got two of them. Take you in the white shirt.
I'm sorry if I got two parts.
That's okay.
But I'm not sure, but has the defendant already served time? And if so, and you guys decide to, or the court decides to agree with his motion to suppress the evidence, is that going to go to another trial, or will he be like awarded some sort of settlement from the state?
In general. You'll see in general. We'll talk about this case, but in general.
So generally, in a criminal case, the defendant may or may not be incarcerated while the appeal is pending. And that depends on the kind of conviction at issue. So it varies from case to case, whether or not the defendant's incarcerated or not. If a case is reversed, then usually the conviction would be vacated, and then the case would be sent back down to the district court for further proceedings as necessary. That's usually how it would work.
One more question that's on someone over here. Yes, sir.
No, sir. I was just making sure my student was seen.
Okay. Anyone, I thought I saw another man in that corner. Maybe not. Go ahead, yell it out.
How often do you guys travel like this from county to county to do these cases in the county that the trial is happening?
Well, Justice Waterman has more time in court than I do, and because of COVID, it was unusual year. So I'm going to let him summarize historically what we've done.
So we started in 2012 at taking court on the road. We've now been to 30 different Iowa cities, and in connection with those visits, the 7 of us will fan out to different high schools or local colleges and give talks. We were doing 2 in the fall, 2 in the spring, plus going to the Beach Law School and doing a night court in Des Moines. And then COVID hit, so we were going to be here 18 months ago, and I hope it was worth the wait for all of you.
By the way, we were supposed to come to Oskaloosa about a week before COVID shut down the world, and we were getting a little bit skittish about it, and we hesitated calling Oskaloosa. Well, apparently Oskaloosa was getting a little bit skittish about us coming to town. So we were actually quite relieved, both sides, to sit and put a pin in this. And so Oskaloosa was the first community that we asked once we were ready to go on the road again. And you guys said yes, thank you very much. Makes you make us feel at home. Well, without any further questions, we'll come out in the hallway and certainly will continue to engage with you if anybody has any questions other than this case. And at this time, court is adjourned.